Andrew Ferguson here. I'd like to add my own personal congratulations to the new board. I think you see here today the high bar that they have, that this board has set in bringing together some wonderful speakers and engaging people in a very important topic. The topic of this symposium is life after the war on drugs. And within after, there is a temporal understanding that there was a pre-war of drugs and during war of drugs and now after. And that timing is important because it is part of a larger timing and a larger context of history, American history. What we're going to talk about today in this session is about the tensions between federal and state law, a tension that dates back to the founding of our country. And it has evolved over time and is constantly evolving. For those of you who are students here, you are living through the perhaps end of the war on drugs, and the next chapter is not yet written. And it is being written by people who are both in the mix of professional law, both prosecuting and defending, and people who are commenting on it. And we have two wonderful examples here today to talk to you. Professor Kreit is currently the director of the Center of Law and Social Justice at the Thomas Jefferson School of Law in San Diego, California. He's an associate professor who's developed a national recognition really as an expert in the field of the evolving drug laws. I spent some time this week reading his work, and it's impressive and it's well-deserved, and we're lucky to have him flying in from California to speak to you here. He teaches classes on the subject. He's writing, I think it's not quite yet published, a casebook on drug abuse and the law called Controlled Substances, Crime, Regulation, and Policy. Perhaps we'll do a seminar class on that sometime. He was also, most recently, the co-chair of the legal committee for the Yes 119 campaign. Many of you may be familiar with the campaign in California focused on the legality of marijuana, and Alex was one of the head legal minds behind that effort. He is both involved academically and practically in the subject, and we're lucky to have him. Complementing him in a way that I think will make this panel wonderfully is Robert Hildum, who has been, I think this is correct, both a federal prosecutor and a state prosecutor involved in drug crimes, as well as a defense lawyer defending federal crimes and state crimes on occasion. He is presently the Deputy Attorney General for Public Safety at the Office of Attorney General here in D.C., and as this is the Public Law School of D.C., is going to bring some context about what's going on here in Washington. He has had that job since 2007 with the brief stint when he was actually the director of the Department of Youth and Rehabilitation Services of District of Columbia, meaning he ran the entire DYRS in D.C. He started out as assistant DA in New Orleans and was a partner at a law firm where he specialized in criminal defense. He's done both prosecution and defense. I think he will offer, as I've heard him speak before, a wonderful perspective on some of this tension, this ongoing tension that will continue to be tension of federal and state crimes, drug crimes in America. So, turn it over to Professor Kreit.
Actually, I think we've switched up on it. Sorry, Professor. Yes, sir. Thank you all. It's a pleasure to be here. I think this is, I can't even count how many times I've showed up at UDC at the invitation of Dean Broderick, and I'm very pleased to be here again. I'm pleased to be here to talk about this topic because often Dean has asked me to come and put on my prosecutor hat, and I take positions to sort of create debate, but not necessarily things I agree with. And I did that a few months ago, and I really wasn't very happy with the positions I was taking, and I think we were talking about distinction between crack and powder. But I'm always happy to be here, and I'm particularly happy to be here today. One of the roles that I've had as Deputy for Public Safety is assisting peripherally. I'm not going to say I wrote the rules, but certainly participated in writing the rules and regulations related to Washington, D.C.'s passage of a medicinal marijuana statute last summer. And I have to tell you, personally, I have had two siblings who have passed away. One from AIDS in 1992, and my sister 2 years ago from breast cancer. Back in 1992, we were just learning how to treat AIDS and pain management and things like that. So I don't think that marijuana was an option at that time. It is something that's being used now to treat conditions. But my sister passed away from breast cancer. The issue in her case wasn't marijuana, but pain management. And I think one of the things that allowed her to pass away with dignity, and I think also in her final days, when I was with her in her final days, to come to terms with her faith. And her faith and her spirituality was the fact that she was pain-free. And it was not marijuana, but it was morphine. But I think those are the personal issues that have turned this debate over the last few years. Is that as conservative as some of the congressmen are, as conservative as some people are, we all have family members, friends, who suffer from glaucoma, other diseases that we are now learning can be helped by the use of marijuana in some form or another. So I think that's an important thing, that I think we're starting to see a little more compassion. Although what's interesting is, in some of the research I've been doing, you're only seeing, I think it's 16 states that have passed medicinal marijuana laws. And it's an interesting list because you've got very conservative states, some of which you call very liberal states. California, and then you've got Maine, and then some other states in between. So it's in Montana. It's an interesting mixture of states that have decided to do this. But I'm very proud of the District of Columbia for having passed the statute. The problem that we are running into is the details, is setting this thing up. And we have written, the rules are online, I can probably get a copy. They're 82 pages. They mostly deal with registration, how people register, how doctors can prescribe marijuana, and then you get into the producers, the growers of marijuana, and then the distribution points of marijuana. Right now we have limited in the rules to 10 cultivation centers and 7 distribution centers. We've limited the cultivation centers to 95 plants. So, you know, getting started, I think there may be some difficulties. There may be some difficulties for an entrepreneur who wants to do this in terms of being able to make a profit from it. And I don't know what the profit margin is. I don't know the mechanics of the business of it, but it sounds like it's a difficult process. There were options, I think, that could have been imported from another state. I mean, they transport prescription narcotics all the time, and that was suggested. It was rejected. They wanted grown here locally. Talking about federal involvement, as many of you may know, when the District of Columbia passes certain legislation and medicinal marijuana would fall into this category, there's what's called a passive review period by Congress. That means that after, I can't remember if it's 30 or 60, I think it's 30 or 60 congressional days, it becomes law if Congress takes no action. What's interesting for the purposes of the symposium is that time period passed. Congress took no action whatsoever. So it became law, and as of January 1st, it is law. Now, it is not being implemented until the current mayor decides what, and this is one issue we have. Of course, we have a transition from Mayor Ferguson to Mayor Kreit, and there is currently an analysis of the best way to administer this program. Originally, ABRA, the Alcoholic Beverage Regulatory Agency, which oversees liquor stores and bars and things like that, was going to assist in the licensing of producers and distributors alongside the Department of Health. And again, for purposes of the seminar, and I think it's a very interesting debate that we had, the concern was if we give it this responsibility, part of this responsibility for licensing to the Alcoholic Beverage Regulatory Agency, ABRA, what will Congress do? Would they say, what are you trying to do? You're putting marijuana with legal alcoholic beverages. You're saying this is recreational. And this was a real debate and a real concern among all of us who were writing these rules and regulations. And we were concerned that Congress might come in. So, as we are writing this law, we're writing these regulations, this is in the back of our mind. The current administration, I believe, is of the mind that it should all be with the Department of Health. And so they are looking at that, and hopefully soon they will begin the active process of licensing distributors and producers here in the District of Columbia. One interesting question that came up actually last couple of days was somebody was talking to one of the special counsels at the U.S. Attorney's Office and said, well, how are we going to get the seeds into the district? And that's a real question. How are we going to get the seeds here? I know they're already here. I know they're already here. But that does get into other issues. Professor might talk about is the quality assurance and the type of marijuana. And I mean, all these things, the cultivation standards and so forth. From the perspective of law enforcement, one big question is, how are you going to secure this? You put a sign up that says medicinal marijuana, that's going to draw some attention. What kind of security is needed? Where will they be? There's quite a few neighborhoods that really welcome this, and there's actually provisions in the rules and regulations that require notice to the community and things like that this is being proposed. So, another issue is I don't know anybody in the district government who knows what these places are supposed to look like. How they're supposed to be secured, all those things. I mean, I can tell you there was discussion that, well, maybe some of us should go visit a state that's doing it. We looked down the list and everybody seemed pointing to Hawaii. And if any of you ever get into government work, you will know that a government trip to Hawaii is the holy grail of government.
It's a touchy subject around here at the moment.
That is it's a whole other seminar. When I was with the Commodity Futures Trading Commission prosecuting commodities fraud, we desperately tried to file a case in Hawaii. But these are real issues. I hope that we can solve them quickly. Not particularly in my hands right now. Good people are looking at it. People who I think feel the same way compassionately about the need to have this. So in that regard, I'm really proud of the District of Columbia. Now, we have not heard any rumblings from Capitol Hill, which we sometimes hear. And we don't have any indication that Congress is going to try and undo this law or step in or do anything like that. The interesting thing about the limit of 95 plants, just to let you know, is I think that came from Councilmember Catania when he introduced this legislation, and the concept was that the feds won't prosecute anybody with less than 100 plants. We've since learned that that's just ridiculous, and that's never been a policy. Don't know where you got that from. But we are in talks with both the DEA and the U.S. Attorney's Office. It's heartening that Attorney General Holder has issued his statement that he's not going to interfere with people who are following the laws in the state on medicinal marijuana use. So it is going to be a very, very interesting time in the next few months in the District of Columbia. And it's going to be a lot of legal maneuvering. It's going to be a lot of discussion. Hopefully, and I hope this for the people who desperately need this medication, is hopefully it will not take too long, but it is a complicated process, far more complicated than I thought it would be. And I'm certain there are many people in the District of Columbia who say, I don't know why you're doing this, I can tell you what I know there are. So that's really most of the update I have from the district. You know, one thing I have to tell you from my time as a defense attorney is I'm always cognizant of this time of the year because I practiced in Baton Rouge, Louisiana, which is on Interstate 10, which runs really from California to Florida, but primarily Houston to Florida. And it's harvesting season, which was like Christmas to criminal defense lawyers because we got lots of phone calls of people stopped on I-10 who needed representation because there was apparently all of this marijuana in their 18-wheeler that they had absolutely no idea how to got there. So I always think of that in the spring, and I think of my law partners who are still back there who are, you know, it's basically Christmas time for them right now. But a very serious topic, and I, you know, the few minutes that I was here reading the rest of the symposium topics, it really is an interesting time. It's a very interesting time to discuss this topic, to discuss historically where we were with the war on drugs and where we're going. And I think it's very interesting to see the shift in even the most conservative members of the Congress who appear to be okay with medicinal marijuana at this point. And I think 81% of the American public is in favor of it. So very, very interesting time, very timely topic. And I'm sure you'll have a lot more questions for the professor than me. And I'm going to turn it over to the professor, but you know, happy to take any questions you might have. So thank you very much.
Thanks so much for having me here. It's really great to be here, especially with Professor Ferguson moderating, whose work on high crime areas scholarship in that subject I really admire. I'm especially glad to be talking here at this symposium on the topic of life after the war, because I think that one of the key questions that we're going to see in terms of a post-war drug policy is how federal law is going to interact with state reforms. Because I think we're going to see, and we have seen already, that states are probably going to lead the way in terms of reforming drug laws. The federal government, I think the role, the key question that federal law will face is how are they going to, how's the federal government, how's the federal law going to react to these state reforms? And I do think that we are seeing the end of the war on drugs. If you are to believe Gil Kurlikowski, president of All Those Drugs Are, he said he ended the war 2 years ago when he took office. When he, in his interview prior to taking office, said that he didn't think we should use the phrase the war on drugs. He recently reiterated the idea that, as far as he's concerned, the drug war is over. Of course, all the drug war laws remain in effect and the drug war policies continue. So some have sort of said, well, maybe this is more rhetoric than anything else. Of course, in fairness, can't end a 4-decade-long war overnight. But I do think it sort of raises the question, a serious question of what does a post-drug war policy look like? And again, I think the key, or one of the very key questions that's going to arise in this area is how should and how will federal law interact with state law? We've seen, of course, already federal law reacting to state medical marijuana. So the laws legalizing medical marijuana in a number of states. And I think the likelihood is that in the next few years, we're going to see one or more states legalize marijuana for recreational purposes. In 2010, California, of course, almost did just that with Prop 19. Proposition 19 would have tax regulated and controlled marijuana within the state. It got 46.5% of the vote, so just missing passing. But I can tell you that efforts are underway to bring a similar ballot measure back before voters in California in 2012. Similar efforts are underway in Colorado, and I think you'll probably see in 2012 at least a few states with marijuana legalization ballot measures before the voters, and you're going to see some legislatures take the issue up. In California, in fact, before Proposition 19, was even gathering signatures to get it on the ballot. Assemblymember Tom Ammiano in California proposed legalizing marijuana through legislation in the state, and a few weeks ago some state legislators in Rhode Island proposed a bill to legalize marijuana there. So I think given all that and sort of the increasing public support for marijuana legalization, if I had to bet money, I think you would probably see more and more states within 2 to 4 years having passed marijuana legalization ballot measures, which sort of raises the question of what is the federal government going to do if that happens. In an earlier paper that I published last year, I looked at some of the issues surrounding federal enforcement with regards to state medical marijuana laws. I want to build in my presentation today on some of what I talked about in that paper and look sort of further at what I discussed there by looking specifically at the idea of how, to what extent, the federal government can block state marijuana legalization. So if a state were to legalize marijuana, what could the federal government do to try and block those laws if it wanted to? And I'm going to suggest that in the long term, they can't do very much without substantially changing, in a way that I don't think they will, their resource allocation. Because of that, I think the federal government is going to have to, at some point, start taking the position that when it comes to state reforms, they have to sort of acknowledge the reality that they can't block them, they can't interfere with them, whether they like them or not. The best approach is to acknowledge them and formalize some sort of respect for them within the law. So the first point that I want to talk about is to sort of highlight the relatively small role that the federal government has in drug enforcement, which I think is oftentimes a surprise to folks. But as a practical matter, the war on drugs is waged not by federal law enforcement, but by state and local law enforcement. This is particularly true when you're talking about smaller time offenders, drug users, but it's true generally, even when you're talking about street level dealers and the like. To give you a sense of this, in 2008 there were about 750,000 arrests nationwide for marijuana possession. During that same year, there were only 626 simple marijuana possession cases disposed of in federal court. In other words, hardly any. Many of those cases, although we don't know from the statistics, almost surely were cases that didn't start out as simple marijuana possession cases, but were cases that led down to simple marijuana possession, or were cases that were in the federal courts for a specific reason. For example, somebody's caught, on an army base with some small amount of marijuana or the like. If you look,
Wolf trap.
yeah, exactly. And if you look beyond simple marijuana possession to arrests and prosecutions generally, even there, in terms of manufacture, in terms of drug distribution, the federal government has a relatively small role. Last year, there were about 100,000 marijuana trafficking and sale arrests nationwide. During that same year, there were only 4,000 648 marijuana distribution manufacture cases disposed of in federal court, along with an additional 1,300 importation cases, which is sort of categorized in sort of an area unto its own. But even if you want to factor those in as sort of manufacturer sale cases generally, you've only got about 5% of those cases being handled in the federal courts. And so because of this, when during the Proposition 19 campaign, Eric Holder released a letter vowing to vigorously enforce federal law in the state of California, Proposition 19 should pass, you kind of wonder, well, as vigorously as you might enforce it, how much of an impact would it have? When he released this letter, Eric Holder, saying that he would vigorously enforce federal law during the Proposition 19 campaign, Proposition 19 opponents seized on this to basically argue there's no reason to even bother voting for Proposition 19 because it's a dead letter. Sheriff Lee Baca from Los Angeles County said that, quote, you can't make a law in contradiction to federal law as a state, therefore Proposition 19 is null and void and dead on arrival. I think, however, there was a part of, and this is sort of the media coverage sort of seized on this, and there was a flurry of news articles and television stories about, well, Proposition 19 is just in conflict with federal law anyway, so, it will never take effect. I think another part of Eric Holder's letter, though, with regard to Proposition 19 was a little bit more telling. Holder in the letter argued that by prohibiting, quote, state and local law enforcement from seizing marijuana that is in compliance with state law, end quote, Proposition 19 would, quote, provide a significant impediment, end quote, to federal law enforcement partnerships with state and local agencies. And I think that that's more telling because it really highlights what I think is the federal government's main concern about the idea of a state legalizing marijuana and with regard to the state medical marijuana laws, which is we're going to lose all of the foot soldiers, all the people who are really enforcing the norm of prohibition if you have a state enacting a marijuana legalization law or when you have states enacting these medical marijuana laws. And to see how this plays out a bit more, we really can just look at the example of medical marijuana. Medical marijuana, the federal government, up until recently with the Obama administration, had taken what I think it's fair to say is a very aggressive, active approach in hoping to interfere with and block state medical marijuana laws. When California first passed its medical marijuana law in 1996, the federal government filed civil suits to enjoin medical marijuana dispensaries from operating. They took the issue went all the way to the United States Supreme Court, the Candace Myers cooperative case, where the court said there was no medical necessity defense under the Federal Controlled Substances Act. The federal government threatened doctors who recommended medical marijuana, saying that if they did so, they'd lose their license to prescribe controlled substances, which, if they had succeeded in that, it would have been I think, I think very well could have shut down the state medical marijuana laws because no doctor is going to want to lose that license to prescribe controlled substances. That issue went to the Ninth Circuit in the late 90s, early 2000s, and the Ninth Circuit said the federal government couldn't do that because doctors had a free speech right to tell their patients their honest medical opinions, including that they thought marijuana would be beneficial. The federal government, of course, criminally prosecuted people vigorously who were medical marijuana, involved with medical marijuana in states that had legalized it for medical use. And even today, in spite of Eric Holder's memo to the contrary, saying that the Department of Justice doesn't have an interest in going after individuals who are in unambiguous compliance with state law, I can tell you for a fact they continue to arrest and prosecute people who are operating in compliance with state laws. I know of a number of cases in California where they've done so, and their position is in court that those people cannot come into court and argue as an offense that they were operating in compliance with state laws. The distinction that they seem to make is, in essence, if you are involved in a dispensary, you are therefore selling, the memo doesn't necessarily apply to you, and in any event, the memo is just a sort of informal guidance to local offices. Ultimately, the discretion sort of is in their hands. Despite all the federal efforts, though, to interfere with state medical marijuana laws, they really haven't been very successful. Even before President Obama took office and Eric Holder released the memo, supposedly respecting state medical marijuana laws, there were over 700 medical marijuana dispensaries operating openly in the state of California. There were more than 200,000 medical marijuana, an estimated more than 200,000 medical marijuana patients in the state of California. And you might wonder, well, why is this? Right? I mean, it was at a time where President Bush and his administration was vigorously enforcing federal drug laws, prosecuting medical marijuana dispensaries, etc. The reality is the federal government doesn't have the resources to block these state reforms. It's a simple matter, if you might, remember back to your criminal law class, the idea of deterrence, right? How much enforcement is going to take to deter people. The federal government is simply not able to prosecute enough people, to arrest, investigate, etc., enough people who are involved in these medical marijuana dispensaries to sufficiently deter the activity. In California, they were able to slow it down over some period. Right? It wasn't until about 10 years after enactment of Proposition 215, California's medical marijuana law in 1996, that you really started to see a real proliferation of medical marijuana dispensaries in the state. But once it sort of reached a critical mass, dispensary operators, even though they knew full well that if they were prosecuted federally, they had in essence no defense. They were certain to be convicted, and because they were operating out in the open, they were relatively easy targets for the federal government to investigate and go after, were still operating open, even under President Bush, because the federal government simply didn't have the resources to prosecute, investigate enough of them to deter them. And you can see and imagine, just given the sort of brief statistics I highlighted in terms of overall federal prosecutions, that even if the federal government was just interested in going after medical marijuana dispensaries, for example, they would have to radically and fundamentally alter their enforcement resources if they had any hope of effectively doing so. Right? There are about 4,600 federal prosecutions for marijuana distribution and manufacture at the federal level nationwide in 2010. If they were to go after today, nearly 1,000 or more, depending on the estimates, medical marijuana dispensaries operating openly in California, that'd be about 1/5 of the number of marijuana manufacturer distribution cases they bring all across the country. I mean, they really would have to radically alter what they're doing if they wanted to go after enough of these places to try and sufficiently deter them. Because of this, even though the federal government has the power, has the authority, and under the Raich case, which was a Commerce Clause case, the Supreme Court held point blank, the federal government can legally enforce the Controlled Substances Act against anyone in compliance with state law, even the most minor offender who just is in possession of a small amount of marijuana for personal use, for personal medicinal use. It's constitutional for the federal government to enforce the Controlled Substances Act in those situations. The reality is they just don't have the resources, absent a dramatic change in what they do, to go after enough people in this circumstance to deter them. And this is just talking about and thinking about the people on the distribution dispensaries. You can see what would happen if we talk about the user. And so this sort of brings us back to the question of what would have happened if Proposition 19 had passed, or say if in 2012, a ballot initiative or one or more ballot initiatives passes to legalize marijuana completely within the state. And there I want to sort of draw two distinctions about what the federal government can do to interfere. And they sort of mirror what Proposition 19 would have done. There are two aspects of Proposition 19 that I think are relevant here to this discussion. One of the components was what I would call the decriminalization component of Proposition 19. Proposition 19 would have made it legal throughout the state of California for adults to possess and cultivate for personal use up to 1 ounce of marijuana for any purposes, recreational or otherwise. The federal government would be, there's really nothing the federal government could do to interfere with that aspect of Proposition 19. There's no question that the federal government could not preempt the state law along those lines. First of all, the Controlled Substances Act's preemption provision is actually a relatively narrow preemption provision. But even if the federal government wanted to enact a broad preemption provision, the federal government simply cannot dictate to the states what conduct it makes illegal or legal. That would violate the anti-commandeering principle that's constitutionally rooted. So the federal government could not come into court and say, well, on a preemption basis to the state, you have to make marijuana illegal and use your state resources to do so. In terms of federal enforcement, while the federal government no doubt could continue if it wanted to, it could make an effort to go after the roughly 60,000 simple possession arrests that existed in California in 2008, they just don't have the resources to do something. The idea of thinking about the federal government suddenly trying to arrest and prosecute 60,000 people for simple marijuana possession just in one state alone is sort of laughable when you think about the fact that there's less than 1,000 simple marijuana arrests, simple marijuana prosecutions in the federal courts nationwide. They'd have to do 60 times that number in one state alone if they wanted to have if they wanted to have that same level of marijuana prosecutions. The other aspect of why this would happen, why the federal government wouldn't be able to interfere in that area, really comes from sort of a more practical aspect of enforcement, which is that the vast majority of people who are arrested and prosecuted for simple marijuana possession come into contact with local police, state police, in a way that the federal government is just never going to come into contact with those people directly. For example, people who are pulled over for a speeding ticket and consent to a search, or if we have the police officer say they smell marijuana and they search the car, somebody who police see on the street smoking marijuana, somebody who, a neighbor calls the local police and say, well, I smell marijuana next door. Unless the DEA were to create a whole new street-level type of law enforcement group, there's just no way they're ever going to come into contact with people to prosecute them for simple marijuana possession, let alone if they did, would the federal government have the resources to do so. So in terms of that criminalization aspect of any legalization measure, the aspect of any legalization measure that would make it legal for adults to possess and potentially cultivate some amount of marijuana in the state, there's really next to nothing, I believe, the federal government could do to block that type of law. Now, what the federal government, I think, would have more power to do, potentially, is block sale and distribution. And you see this somewhat with medical marijuana. But the federal government was able to sort of slow down the development of dispensaries, medical marijuana dispensaries in states that have medical marijuana laws, but ultimately has not been successful at stopping them. And even under the Bush administration, which aimed to vigorously interfere with those laws. Proposition 19 is, I think, an interesting law to look at in this respect to sort of see the limits of what the federal government could do. Proposition 19 would not have made marijuana legal to sell, to manufacture for sale, etc. across the state. Instead, what Proposition 19 would have done is it would have allowed localities, cities and counties, if they wanted to legalize sale and distribution within that locality, to basically enact a law within a city or within a county to tax, regulate, and control marijuana within that city or county. Now, because of that, I think Proposition 19 would have been a law that the federal government could have more effectively interfered with and blocked, at least for some time, with respect to the sale and distribution aspect. Why? Because the likelihood is only a few localities, at least in the short term, would have enacted these sorts of sale and distribution laws. Let's say 5 or 10 cities enacted this sort of a law. Now the federal government would have had a much more limited and much more targeted number of people to go after to try and block implementation of Proposition 19. If they wanted to stop the sale distribution component of the law, they would have only had to target 5 to 10 cities in the state of California, whichever cities and counties enacted these laws, and either criminally prosecuted anybody who opened up shop, or I think more likely filed for an injunction against anybody who sought to obtain a business license in one of those localities, the way they did in their early response to medical marijuana. So, ironically, and this is one of the things that I think is sort of problematic about the federal government's current approach to these state reforms. The federal law as it stands now gives states and gives people who are looking to write these state marijuana legalization laws or state medical marijuana laws an odd, perverse incentive to have broader laws to allow for less controlled activity, because that is the type of law that the federal government is going to be least able to interfere with. You can see this especially when you think about medical marijuana. For medical marijuana, a few states have actually talked about the idea of having state-run medical marijuana systems, where the state would manufacture and control and distribute directly medical marijuana to patients. You'd think that those would probably be the most controlled type of a system. Right? If you're going to have medical marijuana, let's say you're a medical marijuana opponent, if you're going to have a medical marijuana law, you probably think, well, better that it be very, very strictly controlled and run by the state than have a system like what you have in California or Colorado with hundreds and hundreds of medical marijuana dispensaries operating privately. But because of the status of federal law, those types of programs where states would seek to have a state-run medical marijuana facility are the ones that states literally cannot enact, because they would require state actors to violate federal drug laws. And so when they've been proposed in states, they are immediately rejected. So you have an odd sort of situation now, I think, when it comes to federal interaction with the states. The federal government doesn't have the resources to really effectively interfere with state reforms like medical marijuana legalization or marijuana legalization. They can maybe slow them down, block them over some period of time, but ultimately I think, as we see for medical marijuana, it's a situation where they really can't stop them from being implemented. But because marijuana remains illegal for any purpose under federal law, and the federal government has resisted formally acknowledging these state reforms, it makes it impossible for states to have some of the controls that you would probably most want to see. For example, with medical marijuana, you probably want to see in any really controlled system some sort of a state-run process for quality control, where the state would test the medical marijuana to ensure the THC levels, to ensure that it was proper quality, all those things. But states can't do that, because if they were to do that, state actors implementing those laws would be violating the Federal Controlled Substances Act. They would be in possession of a controlled substance anytime they tested the medical marijuana. And so this is a problem that I think is only going to sort of get worse over time as states enact more and more reforms. A problem where the federal government is put in an awkward position where they can't stop these state reforms, and where their efforts to try and block them, I think, ironically, sort of result in a worse situation, a less controlled situation. A situation where they can't prosecute enough people to stop these medical marijuana dispensaries from opening up, but they can prosecute enough people to make it very hard to control them as precisely as we might want. So I will leave it there. Thanks.
On behalf of the law school, I'd like to thank both presenters, and I'd like to offer a comment and then a question, and then I'll open it up to others. Prior to joining the law faculty, I considered myself a foot soldier in the war on drugs, defending people charged with both possession and distribution of narcotics in Washington, D.C. And I think if you went down the street to Superior Court and asked the people arrested there if we were in the post-war on drugs phase, you would get a different answer. In fact, I think they'd say they were taking heavy fire and that it was, we're thankful that they didn't have the real arsenal against them of the federal drug cases. So I wonder, as part of my comment, whether our move past the war on drugs is perhaps more limited to marijuana. We've talked a lot about marijuana, and certainly medical marijuana, as perhaps there is a Cold War phase going on with marijuana, and the hot war is still on with other forms. I mean, even if you were at the lunch presentation, you heard the U.S. Attorney talking about the reality of PCP, how D.C. in this after the war on drugs phase up the penalties for marijuana dipped in PCP, right? So dangerous drug, reality, there's lots of sadness and loss with PCP, but also a move away from it. So maybe the war on drugs is simply evolving. But I wanted to sort of link back to this panel, because the thing that I heard about the lack of the inability of the federal government to prosecute these crimes was primarily one of resources. You say, in California, there just were too many dispensaries, too many users, there's no way they could do without devoting all the federal government to it. It would seem that the model for medical marijuana in Washington, D.C. that has been proposed is one of the easy targets. If you have these 70 dispensaries, each with 95 plants, not too many prosecutions need to be brought forth to shut that down. And I guess my question would be, is D.C. a place where that tension, if it doesn't seem like the Obama administration necessarily wants to take that on, but if there were a different administration or a different drug czar, if we have it anymore, whether that would be, whether the model that D.C. has adopted, Mr. Hildum has helped design, is perhaps the easy target to shut down because you could take the few places with the few plants and target that. I just open that up as a question, and we'll take questions from the audience.
I guess the first answer would be, well, I hope not. Right. I mean, it raises a great point. I mean, at this point, we have not gotten any indication that that's going to happen. I don't know, and the professor could speak to this, if the feds are genuinely looking at the 10 cultivation centers and the 7 distribution centers and saying, okay, follow the regulations, and if somebody is actually selling that back door, or they're cultivating thousands of plants, and I'm not sure anybody would argue, that's not what we gave you the license for. But we have gotten indications from the U.S. Attorney's Office and the DEA that they want to talk to us about this as we go forward, and the indication doesn't seem to be, if you do it, we're going to go after you. So it's going to be interesting, it'll be really interesting for California and other states because of the small, and it's a great point, because of the small number of licenses that will be handed out. What's going to happen going forward, but truly we have not had an indication from either Congress or the federal authorities that they were going to substantially interfere. So I don't know. It's something we have to look and see.
Perhaps you shouldn't put the dispensary right outside the Capitol.
Although, some of the things Congress has been doing, I'm not sure what's going on in the Capitol.
I would say, that was a really good point, which is, right now, I think, under the holder's policy, under the Obama administration's policy, you have sort of a policy of uncertainty, and a policy of, I would say maybe a sort of U.S. Attorney's Office by U.S. Attorney's Office approach, where if you have a situation like in D.C. where there's a relationship where the U.S. Attorney's Office says, we're really going to respect what Eric Holder's letter says, and we're not going to go after dispensaries, then I think the dispensaries system can operate with confidence, with relative confidence, that the people who open up shop aren't going to be facing charges because there's that sort of relationship. But when it comes to other U.S. attorneys' offices that want to take a different approach, Eric Holder's memo doesn't stop them, and certainly hasn't stopped them from continuing to prosecute people who are in compliance with these state medical marijuana laws. And so it is sort of an odd situation where, in San Diego, for example, that's one of the, where I live, that's one of the areas where even after Holder's memo, people who are operating medical marijuana dispensaries, in compliance with state laws have been prosecuted. And they've taken the position, federal prosecutors in those cases, that you can't come into court and use as a defense, I was in compliance with state law, because Holder's memo doesn't give you any sort of legal rights. It's just basically an advisory sort of memo about how resources should be spent. So I think, it's one of those things where right now, the program in D.C., and if there is that sort of relationship with the U.S. Attorney's Office, with the DA here, I think can operate confidently that they're not going to, that people who get licenses aren't going to face federal charges. But the concern is, and I think the reality is, that if you get another administration, or maybe even a different U.S. attorney under this administration that takes a different view, then that puts it all in jeopardy. Unless and until you sort of formalize that respect for state reforms, I think you're going to have a sort of system of uncertainty. Another thing that I would just note on that, which is a great point that you raised, the idea of sort of, are we really facing the end of the war on drugs? Even when it comes to marijuana, I think it's still a war going on. In New York, there was a record number of marijuana possession arrests just this last year from any time previously. And you haven't, nationwide seen any real, the numbers have been, I think, relatively static in terms of marijuana possession arrests. So, I think that you still have, in fact, but and I think people can sort of differ on this, but I'm somebody who thinks that there is a reason for optimism, even in just sort of rhetorical change, from Gil Kurlikowski saying that it's time to end the war on drugs, to have a public health approach, because I think that one of the defining aspects of the war on drugs has really been the rhetoric, the idea that it's a war. The idea that if you propose any sort of reform or any sort of other idea, you're an enemy of the war. And if we have, reduced sentences in this area or that area, then, we're just giving up, in the war. And I think the first step, and I think it's a very important step, to ending the war is just the rhetorical idea of we are no longer in a war against drugs. And I think that once that rhetoric is pushed aside, that's when the policy space is created for having real reforms that would, in fact, end the war. But I think it's going to be a long time. It's a 4-decade-long war. I think it'll be a long time before you have a real a policy that looks different enough from the war on drugs that we could actually say, well, we're no longer fighting the war. I think that's still at least a decade or so away, even if the rhetoric has changed from the Drug Czar's office already.
And just one thing to add to that, is the unique situation of the District of Columbia that the U.S. Attorney's Office is basically our local district attorney. I am sometimes referred to as the district's chief prosecutor, but it sounds a little pompous, so I never say it. But basically, I have jurisdiction to prosecute juvenile offenders, and then prosecution for adult criminal offenders for things like drunk driving, quality of life issues like urinating in public, which doesn't sound like a big deal, but I used to live in Mount Pleasant, and they used my garage door as a bathroom, so I can promise you it's a big problem. But in all seriousness, I, as the District of Columbia legal arm, I have very limited prosecutorial authority. So you have a U.S. Attorney's Office that's unique here because he's responsible for street-level crime, homicides, those kind of things that other U.S. Attorney's offices are not responsible for. So when I was doing defense work, it was really frustrating because I always felt like, well, the U.S. Attorney's Office just doesn't have enough to do because they would pick and choose the cases they would want. And then I would end up standing across from 4 assistant U.S. attorneys, 2 DEA agents, an FBI agent. I mean, it was just so much overkill. So to a certain extent, you have a U.S. Attorney's Office here who has really a lot of other responsibilities other than going after possession of marijuana. But, you know, I mean, one thing, in my opinion, that's worth anything is, you know, I mean, you have this circle of poverty, high crime areas, drug use, and whatever way it goes, whether it's drug use, poverty, high crime, I mean, you can always link a lot of crime to drug activity until you get to the issues of poverty. And until we have a meaningful policy for education and for employment east of the river, I mean, we're going to continue to have this vicious circle of crime, poverty, drugs. Go after the drugs because then you're going to be able to get to the crime. But then if you don't solve the poverty issue, it's just never going to work. So I mean, that's where I think that the real issues are, in my opinion.
Sure. Mr. Hildum, you said you've been in negotiations with the Drug Enforcement Administration, which is responsible for enforcing the Controlled Substances Act, which does not recognize any medical use for marijuana. How does the Drug Enforcement Administration negotiate with you when their statute completely denies the recognition of what it is you're trying to accomplish?
I have to correct that. I have not been in negotiations with them. There has been some feelers that the DEA and the U.S. Attorney's Office would like to talk to my colleagues who are working on this. So we haven't even gotten to that point yet. I have no idea. I have no idea at this point.
If I could then change the question slightly, to what extent is the Controlled Substances Act refusal, and therefore the Congress and the DEA administratively, to refuse to recognize that there might be medical value in marijuana, notwithstanding your council and legislatures of other states, the voters of numerous states? To what extent is that the principal obstacle in developing rational state laws going forward?
I mean, I think as we've discussed, I think it is the obstacle. You know, and I don't know, you know, looking at the research and when you talk to people, and I think just about everybody is touched by some kind of illness in the family, close friend, that medicinal marijuana could be prescribed and could give some relief to real pain and suffering. It's interesting, if you look at the list of people who are for it, who are against it, I mean, William F. Buckley, of all people, was for medicinal marijuana, but you've got Mitt Romney, I mean, talking about how things could change. You have hope for a second term for a president, but you have Mitt Romney and Mike Huckabee, former governor of Arkansas, are both against medical marijuana. You know, I mean, I think I was a foot soldier in the war on drugs too. I mean, I'll tell you, I was the proponent of increasing the penalties for PCP, so you can boo and hiss, but I mean, I don't understand opposition to medicinal marijuana, and I'm starting to come to at least a position of, I don't really care if you legalize marijuana or not. I mean, I've always said from the time I started as a prosecutor in 1992 to now that ain't nobody ever got shot on the street corner over weed. You know, the real violent stuff is associated with PCP, cocaine, and you can differ with me and disagree with that, but I mean, you know, I think that we might be trending that way. Some states are getting there. I think that a lot of people aren't that concerned about marijuana. I mean, it does raise interesting questions. Having run the Department of Youth Rehabilitation Services, we routinely did drug testing. And if it tested positive, it was a reason for immediate termination because they were working with kids. The interesting thing was that all the directors before me refused to submit to a drug test. I did, just sort of as a sign of solidarity. My only fear was that they were going to test for pastry, and then I knew I was in trouble. But it's an interesting policy issue. Is, you know, if it is legal, could you say, well, I don't want you using drugs when you have contact with kids, or if you're, you know, machinery, or if you're a surgeon? Those are interesting policy questions. But you know, I hope that the cooler heads will prevail. I mean, given the compassion that I think is the real essence of the medicinal marijuana debate, that I think you're right. I mean, that probably is the greatest competitor.
I also wonder if there's, whether there's another federalism concern. One of the interesting things about DC is we are a small jurisdiction, and we're not too far away from, say, Virginia, and the U.S. Attorney's Office in Virginia that may have a different state policy as well as a different view of the interpretation of federal drug laws. And one reason why that hasn't played out as too much of attention is that pretty much drugs are illegal. They may have different penalties in Virginia and D.C., but they're still illegal. What would happen from a federalism perspective if D.C. was able to go, you know, forward, that the DEA closed its eyes and wasn't looking at it, but you still have other jurisdictions that would be concerned that suddenly everyone was getting their medical marijuana from D.C., coming over to Virginia, and suddenly there was legally purchased drugs in a state where it's illegal to have, and whether you have, you know, dormant Commerce Clause issues, and all of these things that happen with, you know, states that are close. I mean, it could happen in any state that's close. You know,
Virginia does have a medical marijuana law from the 1970s.
Huh. Do they? I didn't know that. Maryland, I know, has gone to a $100 fine, no jail time if you have a medical excuse. I believe that's correct. So we'll enforce the law, but it's going to be a $100 fine. But I didn't know about Virginia. But I mean, that does lead to some interesting questions, because some of the implements that you use, like I think they use inhalers rather than you know, the traditional smoking, which the DEA will approve any kind of smoking, which I just think is, you know, if you have brain cancer, you know, smoking would be the last thing on my mind. Like, well, I can't do that. That's unhealthy. But you know, those inhalers would be made.
Vaporizer. Technical term is a vaporizer.
Vaporizer. That's right. I'm sorry. The vaporizer would be manufactured somewhere else, more than likely, and then is that a hook for another federal prosecutor?
Yeah, and I think, you know, it raises a point, which is one that you know, is I think sort of important for from the idea of what federal law should look like as more and more states, assuming the trend continues, enact reforms, and not just medical marijuana, but other types of reforms, which is that there might be sort of spillover effects into other states. By sort of taking the position that the federal government has currently, which is, well, it's just illegal for any purpose under federal law, even though the reality is these state laws are being implemented despite what the federal law is. The federal government, you know, not only can't they, are they unable to sort of control or sort of minimize or, you know, constrain, I guess, if you will, these state laws, but they lose out on a number of policy options that they could take if they formally recognize them. For example, the federal government were to take the approach of allowing explicitly states to enact medical marijuana laws or marijuana legalization laws or other types of reforms, they could, as part of that, require states to give, say, some portion of tax revenue over to the federal government for a fund to address these spillover effects that there will be in other states. Or they could say to, for example, the states, you can enact these reforms and we will respect them, but in order for us to, you know, in order for your law to come under the guise of something that we'll respect and that we won't try to interfere with, you have to do X, Y, and Z things. Maybe, for example, one of those things would be in order to obtain medical marijuana, there has to be verification the person's a resident of that state, which would actually, that the constitutionality of whether a state could do that is kind of in question because of the right to travel. But those are the kinds of things that the federal government, I think, in having the policy that they currently do, they're missing out on the potential to kind of constrain these state reforms. And I think that by kind of chasing the illusion that they could block them entirely, which they just, I think as a practical matter, cannot do, they miss out on what they really could have the power to do, I think, which is to try and shape them and constrain them in some ways, which, from the perspective of a drug prohibitionist, I think would be a better alternative than to what you have now in states like California, which is really a not terribly controlled system in a lot of localities at least.
Mr. Newman?
I just had a question. In terms of, I think some people this morning, some of the speakers this morning mentioned it, and it was mentioned here earlier, and I think Professor Ferguson, the war on drugs versus the war on marijuana. We seem to be talking a lot about marijuana and not about the totality of drugs. And I just wanted to get your comments on that, because Professor Ferguson in his comments mentioned it, but it wasn't put out as a question. I know the speaker this morning mentioned some of the heroin, PCP, and some of the other things that were there. Just in terms of the war on drugs, the policy, the economics of it, and the political aspect of it, separating the two, or do you still, or your thoughts about drugs, your thoughts about marijuana the same as all the other drugs, or have you intentionally segmented the two? Because we talk about the war on drugs, but often at the low level, the lowest person on the economic rung is really getting banged up for marijuana, and then move to cocaine, and then the real addictive stuff starts to get into crack and heroin. Where's the, where is it? Maybe there's a cold war on marijuana, we recognize some value on that, but there's no value in heroin and PCP, so we can do something else on that. So can you just kind of speak to that a little bit? I know we're toward the end of the session, but it's a big elephant in the room in terms of, is the war on drugs and everything, or just on everything other than marijuana?
Yeah, I mean, I'd say, well, in terms of this panel, I think because for the federalism issues, so much of the immediate so many of the immediate issues about federalism relate to these state reforms, which are often state medical marijuana laws. But I think, I definitely think that you can't separate out, it's a mistake to separate out marijuana from other drugs and the idea of drug policy reform. You have to look at each drug in each situation individually. But I think that, the war on drugs as a whole has failed. I mean, the war on drugs hasn't succeeded in achieving its goals. We have drugs are just as available today as when the war started 40 years ago. More teens today say it's easier to get marijuana than alcohol. You have decreases in certain use of certain drugs in little periods, but on the whole, you have no real decrease in use of abuse of drugs. And so I think there's really, it's hard to, I think, point to anything and say, well, we've succeeded in the war on drugs. And I think it's a mistake to say, well, if we were to just change policy on marijuana, then suddenly everything would be okay, and it would be okay to lock people away for long mandatory minimum sentences because they pay $1,000 to be a drug courier across the border, which happens all the time. But in terms of the federalism issues specifically, I think that what drives it is these state reforms, and most of them have been marijuana-based. But it's raised an important issue, which is some reforms that haven't come to fruition, but that have been talked about, are ones outside of marijuana, like, for example, safe injection sites or heroin maintenance type programs. The locality might say, in order to minimize the harms associated with heroin addiction, say that we're going to have legally provided heroin to people who register as addicts, or have a site where people can inject safely, or those kinds of things. Those are the kinds of programs that, from the federalism perspective, the federal government would be most able to shut down, because it would be a very contained, specific program. And ironically, those are the types of programs that would have the least impact outside of the locality where it occurred. And I think that they're the kinds of programs that, in any post-drug war policy, I think the federal government needs to allow and respect those programs, because there's a lot of evidence from other countries that have tried these safe injection type programs that they are very effective. Who knows, maybe in the long term, if there are more programs that would prove that they're not as effective as they seem to be in other countries. But they're the kinds of programs that if we really have a public health, science-based approach to drug policy, the federal government should allow, and I think indeed even encourage, states and localities to try out and say, look, we know what we're doing isn't working right now. We know that we haven't achieved the results that we want. We have a lot of costs associated with our current policy. There's no harm, I think, in allowing a locality, if it wants to try out these policies that, evidence from other countries show that they work. And I think that has to be an essential part of any sort of post-drug law policy. And from the federalism perspective in particular, I think it's important to see that the federal government, unless federal law changes, should block a lot of those things from ever happening. And that's, probably the easiest thing for them to block in terms of stopping a state law or local law for localities wanting to open up a safe injection site or heroin maintenance program. It would be very easy for the federal government to just go to that locality and say, no, it's so targeted, it's easy for them to block.
I mean, one thing, I remember very well a case that I defended that involved several defendants in a cocaine distribution ring. And it was a pretty big ring, but I remember at the sentencing, discussing the fact that my client, I can't remember, it might have been somebody else's client, actually approached the ringleader at the funeral of one of his associates who had been killed and wanted to sort of take up where he left off, kind of get the distributorship, if you will. And the judge, who I really admired, said, what am I doing? I mean, he's at the funeral of a kid who was killed dealing drugs, saying, hey, I think I could take over his territory. I think, and I mean, there's just no concept that he's taking over for somebody who'd been killed. So, and then I remember another thoughtful judge said, what are we supposed to tell these kids? I mean, go get a job for minimum wage at McDonald's while your friend can make a few hundred in a couple of hours. And again, I think that comes back to the issues of poverty. That if there isn't any real opportunity, that's the opportunity that it's taken.
This goes deeper, of course, than to poverty. I mean, in other words, you're saying, I spoke this weekend with a woman who's an intensive case manager for kids who were involved in gangs in the suburbs in Langley Park. And, how does a case manager essentially say, I want to make a case that you should follow the rules of being an American when we disregard your status as, you're illegal or your parents are illegal. We disregard your status in terms of citizenship, race, gender, culture, and so on. Oh, but we want you to follow the rules.
I don't have an answer to that. I think those are a lot of the issues. And I often hear also, when you talk about disproportionate contact with the justice system, people always say to me, well, kids in Upper Northwest are smoking weed and they're doing bad things, and yeah, they are. But economics hides a lot. So those kids have basements and they're not on the street. Those kids have disposable income, so they're not stealing. And they're getting iPods and all the things they want for Christmas, so they're not out stealing. Those kids have cars that they can drive up to Great Falls and go, up the goat trail and get stoned up there. If they get caught, there are resources to send them to drug treatment. There are just as many bad parents in Northwest as there are across the river, but when those kids say, I've had it, I'm leaving this house, they'll generally find an upper middle class family to hook up with, as opposed to a lot of kids who say, man, this is not the place for me, I'm getting out of here, and they end up with kids who or families who are probably worse off in some ways than their families. So, you know, when you look at the disparity in wealth, and then, you know, even kids who are using drugs in up the Northwest, and, you know, and I can take my own family. I mean, we didn't have any money growing up, and we were pretty poor, but, you know, my father and my parents, my mother always emphasized education. My brother got stoned before his, you know, his final exams in high school. He graduated 15th out of 300, okay? But, you know, because of this emphasis on education, because we'll do something, we drifted away, okay? Or they did, I never did drugs, but they drifted away from it. A lot of kids here experimenting who are able to drift away. They grow up. They, you know, there's some tragic cases, of course, but the vast majority will experiment and walk away. It doesn't happen so much in the poorer neighborhoods. And so your economic situation can hide a lot, and you are more free to make some really bad errors that you can't make in other areas. So, you know, I mean, the more I think about it, the more I think that, you know, you really have to have, you know, if we get away from the war on drugs, let's try another war on poverty. Let's try something else, because it's just not working.
Mr. Woods, I would only comment that a lot of the same young men from Northwest who were experimenting with drugs get sent off to college, not prison. That sort of happens, shifts, and then they get to do drugs in college, and they have 4 years to experiment. Yeah. Go ahead.
Yes, I think that a lot of the discussion so far is focused on. Sorry. So I think that a lot of the discussion is focused on, I guess, a kind of awkward role the federal government might be in a States Act, and what should they do, et cetera. I'm wondering if you talk more maybe about the potentially awkward role that the courts are going to be in, and what role may they have in resolving some of these federalism issues, and then if they do step in, do we see this being, I guess, contained to the realm of just their treatment of drug issues, or is there going to be a major shift in how they treat federalism issues in general? So I was wondering if you could talk more about judiciary.
Well, I mean, you guys in California have more experience with prosecutions on following state laws. You know, I don't know how much power the judiciary has. I know they think they have a lot. I hear that every day. I know they think they're the prosecutor, but that's another issue. But I mean, I don't know. I mean, if you've got the federal law, if they're showing that it's violated, whether they're following state law or not, there's not a lot a judge may be able to do in that situation. And I'm not sure, you know, then you're going to need a judge who's willing to cross, you know, the federal prosecutor. And there are judges who are willing to do that, but I mean, you know, it would take a lot for a judge to essentially write an opinion that takes away the federal government's ability to prosecute. What do you think?
Yeah, I think that there had been that potential before the Rage case, which basically there was a, you know, which in that case was one of the biggest sort of federalism cases in the past couple decades, but there was an argument to be made that under the commerce power, the federal government didn't have the authority to prosecute or regulate really in any way individuals who are involved in non-commercial drug activity. So in that case, it was individual possession and cultivation of marijuana for medicinal use. But if that case went the other way, I think it would have really formed the basis of saying the federal government just can't, you know, regulate in any way any sort of personal, non-commercial type of involvement with drugs. And that went to the Supreme Court, and the Supreme Court said, you know, no, the federal government does have the power to prosecute people, even in, you know, regardless of the nature of their role. So I think that probably in the courts it's relatively well settled. What you do see sometimes is judges who, you know, trial judges who are very sympathetic to the medical marijuana defendants who are convicted or plea, and either sort of grudgingly, you know, if there's a judge, I think Judge Wu in LA area, maybe he had a really sort of eloquent sentencing memorandum in a medical marijuana case, sort of saying that, you the defendant had done everything that he could to abide by the state laws, and this was before Holder, but he was prosecuted nonetheless. I think he had even had the city officials in the city where he's operating. They came to his ribbon cutting ceremony and everything.
It's the Charles Lynch case, right?
Yeah, exactly. Yeah, the Lynch case, and they were really sort of a eloquent sentencing memo. Why they thought that this guy really shouldn't be getting any time, really. But as a legal matter, there's not a lot. There's still, the Holder memo gives people something to potentially hang their hat on. In these cases, people have argued now with the Holder memo, a sort of public authority or entrapment by estoppel theory, that regardless of what the Eric Holder memo says, that it doesn't give any legal rights, people looking at it might believe that it gives them the right under federal law to start these medical marijuana establishments. Courts have universally rejected that argument. So I think there are a few little legal issues that might continue to bubble up in the courts, but I think most of the main ones have been resolved.
And along those lines, for years, federal judges disagreed with the crack powder distinction, but they still sentenced.
A few more comments, 5 minutes left.
Since you raised the economics issue, let me speak from the economics profession view of this.
Okay.
I'm a retired CIA economic analyst who got interested in drug policy about 40 years ago in grad school. With regard to those inner city use and the job at McDonald's, they probably aren't even available at all for those kids. They can't even get a minimum wage job, so being a low-level drug runner may be their only employment opportunity. But more generally, there are a lot of economists who looked at drug policy just as an issue in efficient public policy making, and they are overwhelmingly opposed, in fact I would say unanimously opposed to current drug policy, partly because we believe pretty strongly in individual liberty, but even more because it grossly fails any kind of cost-benefit analysis. You achieve fairly small reductions in drug use at really enormous costs to society. But the interesting thing is that some of the drug warriors are now starting to use economic arguments in their behalf. They're saying, we know we can't stop drug use, but our actions are forcing the price up substantially, and that reduces use. And as an economist, I have to agree with that. But the economist's answer is, if you want to raise the price of something, there's a much more simple, easier, and effective way to do it. You put a tax on it. And in Europe, gasoline costs $7 or $8 a gallon because of government taxes, and they use a heck of a lot less gas than we do. Maybe just mention a final comment. The most prominent economist I know who's spoken against the drug war is George Shultz, who was President Reagan's Secretary of State, and before that, Secretary of the Treasury. Unfortunately, he didn't say anything about this until he had left his job at the State Department.
We'll take one more question and then we'll...
Can I just say something real? One thing that I always remember when I was defending, you may have had the same experience. I defended some real bad dudes who were dangerous and scary. I also defended a lot of guys who had a natural facility for business, who had a mind for numbers, who had personality, and under different circumstances would have been really successful doing anything else. And that always struck me as very sad, because I'm looking at a guy with really what I believe is natural intelligence, a facility for numbers I don't have, and a lot of ability that's completely wasted because I'm sitting across from him and we're talking about how many years he's going to get in jail. And that always struck me as if there was something else for him that could have grasped his attention or directed him in a different place, we could have really cultivated what seemed to be some incredible ability.
I just, one thing that comes to mind in the comments, which is, again, why I think the idea of just eliminating rhetorically the idea of the war on drugs is so important, because when you have a war, you have a single-minded goal, which is, to stamp out all drug use entirely. When you look at it from a public health type of perspective, then I think the policy room sort of opens up to talk about it for what it is, which is a cost-benefit idea, right? And I think it's something that is so often right now overlooked in the debate, which is, well, if we were to say legalize marijuana, there's some people who really believe that if even it resulted in one more user, then that would just be a terrible policy. But the reality is, it's cost and benefits to anything. And even if you had a policy that raised by 25% or 50% or whatever adult marijuana recreational use, that might be worth it if you save all the money that we're currently spending on law enforcement, on incarcerating people, you take away the other costs of having the illegal market, the violence, etc. And so I think it's so crucial to look at it from a cost-benefit perspective, and my hope is that in moving away from the war on drugs idea, that will create that sort of policy room to talk about this for what it is, which is policy like any other, where we have to look at the costs and look at the benefits, and not be single-mindedly focused on the elusive goal of a drug-free society at any cost, which is what the war on drugs, I think, central mission was. Whatever the cost, we want a drug-free society.
And I think there's still the mentality. I remember, anybody ever seen old episodes of Dragnet? They're actually, the funniest episodes are when they have, quote, hippies on, and they're like wearing brand new, like, secular clothes, and then you've got Jack Webb. And we used to joke, because I remember this line from Jack Webb, that, talking to one of those long-haired hippie freaks, that marijuana is the match that lights the cocaine fuse that leads to the heroin bomb. And I think there's still that mentality that, marijuana legalized leads to all these other things. I personally, I don't think it's a good thing to smoke weed, but it's, I don't think it's a good thing to drink excessively either, but that's legal. And I do think that there are some people who are prone to addiction, but we don't keep alcohol from them. So, these are, but I think that entrenched mentality is still there. That if you take that step, then we're going to have, our nation is going to be completely wiped out because we're all going to be on drugs. And, it won't be the communist hordes anymore. It's going to be terrorists. They're going to come straight down from Canada, because they would seem to come from Canada. And we're going to lose the nation we love. And I think that's a very entrenched mentality that's still there.
One last quick question.
I'd like to sort of segue with that. I think one of the things I've been hearing is that I'm a little concerned about the slipperiness of the language. What we're really talking about is that we live in a society where people use substances, whether they're illicit or illicit. Our American society takes stuff, whether the doctor prescribes it or whether you find it on the street. So what we're really talking about is the misuse of substances that are related to certain kinds of activities that are in our society currently are considered not acceptable. Killing somebody is not acceptable, whether you're drinking, whether you're on a prescribed drug, or whether you're smoking cannabis. So I think if we're going to talk about the future of and moving out, and if we focus on reviewing the past and present, we have to really contextualize where we sit. And that this is an ideological, the war on drugs was highly ideological. It evolved out of not only 40 years of ideological repression and the use of laws as a way to maintain social order, but it's a 100-year-old discussion.
Yeah.
So I think what I'm really concerned about is if we're going to move forward and giving your perspective on the relationship of the federal government to the state government, where is there, for example, in that discussion, the notion of human rights, and that we use human rights as a frame to discuss under policy? Where's harm reduction in this? These, to me, are policy frameworks that allow you to move beyond ideological assumptions, that are evidence-based, that are based on science and health principles, and that might get us out of this mess that we in the U.S. continue to go around. So I'm interested, does that ever come up in this federal state kind of debate?
Well, I think that in terms of federal law, one of the things that I forget who the person who wrote this, but there's recently sort of an interesting article talking about drug regulation generally and comparing sort of the FDA and DEA and the various regulatory overlapping regulatory schemes that we have. And one of the things that you see right now is you're sort of under the Controlled Substances Act. Under federal law, the Controlled Substances Act basically, by definition, means that any drug that's used for recreational purpose is going to be illegal. for that purpose other than alcohol and tobacco, because the Controlled Substances Act explicitly exempts alcohol and tobacco, and then any other mind-altering substance falls under it. And under the Controlled Substances Act, any substance that does not have an accepted medical use is going to, by definition, be in Schedule 1, and meaning it's going to be prohibited. And so, you know, you have a sort of, I think the way drugs are looked at in the law is a little bit of a, you know, schizophrenic way, if you will, where certain types of recreational substances, alcohol and tobacco, are exempted from the Controlled Substances Act and our generally applicable regulatory scheme. And then for all other substances, if it's used recreationally, even if it has a very low potential for abuse, it's going to be prohibited. And if something's used as a medicine, then it's treated in a whole different way entirely. And so I think that in the longer term, I mean, I think there needs to be some sort of broader reassessment of, you know, how that works.
Government should call for another convention. I mean, the U.S. did write the original convention, you know, the call for the convention. So maybe that's, so in terms of getting out from under this notion that we're going to establish with the war on drugs, there is a way that the legal profession could begin to utilize other models and frameworks and call for action that would effectively call into question an outdated, outmoded, totally non-cost benefit related set of policies, so that the convention of Article 72, which we're pretty much working under now, it might be appropriate 30 years later, literally 30 years later, there be a call to action that we re-recognize and look at these conventions that based on current evidence and that we work within this other policy. I mean, if not, it sounds like, let's ask to go back to the comment here. Is this a cannabis discussion, or is this a much larger way that we can rationalize U.S. drug policy? Because this conversation has in essence gone on for almost 25 years, and I think we need to push it and move it a little bit further.
I think it's probably a good way to end this panel and continue the discussion, which will hopefully, this is what symposiums are for, is to continue the discussion. I think it's probably too early to put our mission accomplished banner up there to say it's over and done with, but the conversation continues. I think it's a good point to hopefully those students in the audience are rethinking and recognizing the wonderful law review articles they could write about the new framework to put in there, or professor. And that's your challenge. So thank you, and thank you to our panel.